The President, please be seated. The Chamber has already informed the parties to the proceedings that during today or this afternoon session, the Chamber will be hearing the submissions by parties concerned regarding application for Mr. Khew Somphon's immediate release on bail. As the President of the Trial Chamber and on behalf of my fellow judges, I would like to welcome the co-prosecutors and counsels for Mr. Khew Somphon. The purpose of this hearing is to hear the submission and arguments, oral arguments regarding the application for Mr. Khew Somphon's immediate release on bail and also the responses by the co-prosecutors. In relation to document E275 filed on the 29th of March. And this application is for Mr. Khew Somphon's immediate release on bail. And I would like to pronounce the hearing open now. The trial chamber wishes to remind parties to the proceeding that after it has been seized of the written application for Mr. Khew Somphon's immediate release on bail, the chamber would like to conduct hearings, a hearing on the 5th of April 2013. However, counsel for Mr. Khew Somphon was not available. That is why the chamber rescheduled the hearing to today afternoon so that we can hear submissions by party concerned. The chamber wishes to also inform the co-prosecutors, or the trial chamber has informed the co-prosecutors through senior legal officer that the co-prosecutors would not need to make a written submission, but they would do so in oral in the courtroom today. And the chamber now conducts this hearing to hear the submission by counsels for Mr. Khew Somphon regarding the application for Mr. Khew Somphon's immediate release on bail. Counsels for Mr. Khew Somphon will have 30 minutes for this. Then the chamber would like to hand over to the co-prosecutors to be able to also make a response orally, and the co-prosecutors will be allocated 30 minutes for this as well. And at the end, defense counsel will be allowed some time to reply, and counsel and Mr. Khew Somphon will have 10 minutes for this finally. Next, we would like to hand over to counsels for Mr. Khew Somphon to proceed with their arguments in support of their application for Mr. Khew Somphon's immediate release on bail. International Co-Prosecutor, you on your feet. You may now proceed.
Thank you, Mr. President, and I apologize for intervening so early Good afternoon, Your Honours and Council. The reason I'm on my feet is that we have just received a rather belated application from the Khieu Samphan team under Rule 87.4, and that application concerns this hearing. We understand it was filed in the afternoon yesterday. A courtesy copy was forwarded to us approximately 1 hour before this hearing, and I gather it has just been notified also formally. It is document E280, E280. To the extent that it relates to, that it is an application to admit additional evidence before Your Honours in the course of this hearing, in our respectful submission, it may need to be dealt with before we proceed to the substantive matters. And if Your Honours are inclined to hear submissions on this application, then we would make those submissions. But for now, I just wish to raise the issue and perhaps have some directions from Your Honours.
Mr. President, maybe you would like a bit of clarification. I believe that what the prosecutor is referring to is a submission that we filed today, indeed, yes. We weren't able to do so before because it had to be translated, and this is document E280, and it is called First Request Aiming at Putting on the Case File Excerpts of the Book by Marcel Lemond, free translation. And as your chamber is already aware, the former co-investigating judge, Mr. Marcel Lemond, published in France a book where he describes his experience and his work at the ECCC. And, of course, we intend to use certain excerpts that we quote in this submission. There are not many of them. Submission that the co-prosecutor is aware of. And in order to answer him, I'd like to say that this submission is 8 pages long, whereas on the prosecution side we were given at the same time 5 scientific and medical studies representing about 200 pages in total that I had to examine in order to be able to address the issues during the lunch break. So you see, prosecutor, we should be playing on a level playing field. We are both in the same situation. You are giving me even more, 200 pages of documents in English, whereas I have just finished this morning's hearing examining François Ponchot, and you received from us only 8 pages that have already been translated into English from a rather simple submission that's easy to understand. So I think, Mr. President, this request having been filed, I would like to ask your permission to refer to it during today's hearing.
Thank you, Mr. President. I'll be brief in my response. There is indeed a sea of difference between the documents that we shared with the parties and this application made by Mr. Khieu Samphan. And I think it's important to consider the procedural history here. This is a book that, according to the request itself, has been publicly available since January 2013. And on the 15th of March 2013, the Council for Nuon Chea sought to admit excerpts from this book in an appeal before the Supreme Court chamber. And that was in document E189/3/1/7. So at the very latest, by the 15th of March 2013, all the parties in this courtroom were aware of this book, or this material, which appears to be of interest to the defence. The present request, the application for Mr. Khieu Samphan's release, was filed on the 29th of March 2013, so 2 weeks after a point in time at which all parties must have been on notice of the existence of the book. The request, in fact, makes reference to interviews that former co-investigating Judge Lamond gave in connection with this book, and you can see that at paragraph 6 of the request for Mr. Khieu Samphan's release, which is document E275. Most recently, yesterday, Your Honours have clarified, and this is in memo E276/2, that parties are required to make their Rule 87.4 applications at least 2 weeks before the hearings to which they relate. This application clearly fails to meet that requirement. It is much more than simply putting forward matters that are in the public domain and that relate to a hearing. This is, in effect, an amendment to the application. It actually raises new grounds which were not cited in the original application, and those grounds start from the paragraph 18 of this new Rule 87.4 request. In our respectful submission, it would be contrary to justice and it would be entirely unfair to allow the defence to make these sorts of applications virtually an hour before the hearing. What we have done in the context of the Chamber's directive that we not file a written response, what we have done is forwarded copies of studies which relate to the prevalence of post-traumatic stress disorder in Cambodia and attitudes towards the former Khmer Rouge leaders. These materials contain only a very few pages of relevance, and that can be clearly seen upon a basic review of the table of contents of any of these documents. One can see that the portions in which they relate to these proceedings are extremely brief. What's more, these documents, two of these documents are in fact simply new versions or updated versions of surveys that have previously been filed on the case file. There is no element of surprise. We're working within a very short time frame with competing priorities, and we simply sought to give as much notice as we could that we might refer to very limited sections of these documents. There is a sea of difference between doing that when we haven't been permitted to file a written submission, and counsel who were on notice of this supposed new evidence at the time of their request failed to make a request that it be admitted and then make that request 1 hour before the hearing. So in our respectful submission, this Rule 87.4 application must fail. If my learned friend wishes to have this evidence considered before he proceeds with his application, then the proper thing to do is to make an application to adjourn this hearing to allow us to respond on the Rule 87.4 application and to then deal with the substantive matter. But to present us with these new substantive claims at the last minute is completely unfair and improper. So our respectful submissions are that there are two options available. Council can either make a request for an adjournment of this hearing and for the Rule 87.4 application to be considered, or Your Honours should reject his application and simply proceed with the hearing without these additional materials. Thank you.
Merci.
Thank you, President. I must say that I do not at all appreciate what has just been said by the co-prosecutor, especially when he accuses us of having deliberately gone in violation of the rules that apply to us all, and Your Honours are the first to know. We were informed on the 2nd of April that the hearing on my application for immediate release would be scheduled for either the 5th or today. In any event, our request E280, which concerns Mr. Le Monde's book, has been sent for translation and was sent for translation before the date, and we cannot be accused of having exceeded the deadlines. Once we sent our document to translation, the scheduling of this particular hearing was already set. It seemed the most judicious decision taken by Your Honourable Chamber. I believe that the co-prosecutor should withdraw his criticism in our regard. As for the rest, I think it's rather rich for the co-prosecutor to say that only 200 pages of these medical reports and scientific studies given by the co-prosecutor very well could be cited. As far as you know, the co-prosecutor did not make any written applications. We received documents in their rawest form. They are complicated documents. In fact, they are in very small font, and I can hardly read them. They are full of tables and charts, statistics, findings, so on and so forth. All of this was work that I had to undertake during the lunch hour. And the Chamber is asking us to respond to these 40 documents. I've done the best that I could, given the time given to me, thanks to the contribution of my team to review all of these documents, and I am very much ready and willing to respond to the co-prosecutor. So why is it that he is unable, with all of the means at his disposal, to, during the same period, be just as prepared to respond to a request that consists of no more than 8 pages?
The President, Council, we would like to also hear your response concerning the request to defer the hearing concerning the application for Mr. Kiew Samporn's immediate release on bail, and also the request that document E80 is rejected. These are the two requests made by the co-prosecutors concerning this matter. We would like to hear from you whether the Chamber should conduct the hearing today or should it be deferred to another date. And it is really important that we know from the party, as it affects our decision, and that the Chamber shall issue a decision on this application for Mr. Kiew Samporn immediate release on bail, as it is pursuant to Internal Rule 82 of the ECCC, and we would like to hear from you immediately. And whatever points you raise, please make sure that they are clearly distinguished so that parties to the proceedings and the Chamber itself is well informed. And you may now proceed.
Very well. As far as our request E280 is concerned with respect to the admission into the proceedings of certain passages from the book written by Judge Marcel Le Monde, our position is as follows. We hereby request the Chamber to accept references to be made to a few passages from Monsieur Le Monde's book that can be found in this present application. The co-prosecutor has had largely sufficient time to examine these very few excerpts that are quite easy to understand. With respect to a possible postponement or deferral of this hearing on the immediate release on bail of my client, I do not feel authorized to call for a postponement if, unfortunately, the decision of your honorable chamber is to not allow me to expound on the grounds of my request, then I will therefore be asking for immediate release today. I hope that I have been sufficiently clear.
The President, I now hand over the floor to Judge Civil Cartwright to put a few questions to the defense team for Mr. Kyew Sampon and or other parties concerned. Judge, you have the floor now, please.
Yes, thank you, President. The issue that is before the Chamber is whether to grant leave to the defence to file an additional request for the admission, or to file a request for the admission of a new document pursuant to Rule 87.4. The defence argues that it is only fair that we should allow this document to be considered because the prosecutors themselves filed voluminous material in support of their opposition to the application for immediate release. The primary issue today is that an application for immediate release must be determined as quickly as possible, which is why the Chamber gave a very early date last week, which the defence was unable to take advantage of. The application for the admission of a new document has come as a complete surprise to the trial chamber. We were not aware of its existence until the prosecutors raised this matter at the beginning of this afternoon's hearing. We do not consider we have time to give proper consideration to that application, and therefore the Chamber will not determine the application for admission of the extracts from the former co-investigating judge's book filed today about an hour or so ago. That will follow the normal course for such applications, and the parties will have the opportunity to comment. The Chamber will advise in due course whether those comments should be in writing or made orally. The same criteria must be applied to the application by the prosecutors to admit additional material which it wishes to use as part of its argument in opposition to the application for release from detention. The application for release from detention, for immediate release from detention, will proceed now, and both parties' applications for the admission of documents will be treated in the same way. And it hardly needs to be said that should Kyew Sampon wish to make a further application in relation to release, should he not be successful in the present one, then he is free to do so at any relevant time. But the major problem is that we simply cannot deal with both applications and still give full consideration to Kyew Sampon's application for immediate release from detention. So the President has asked me to indicate that we will proceed with that application now. Thank you. Does that cover it, President?
Fine. Thank you very much, Your Honour. At least what you have said is very clear. So today we are before you with a request which I believe is rather special. It's special because it requires that you, court officers, take a bit of distance from what you're doing regularly, and sometimes this might require that you take into consideration a certain amount of criticism that might be addressed to you, and of course you might be divided about this, and of course we're very much aware of this. I have announced that we were going to file our request for immediate release during the hearings relative to the Supreme Court's, the consequences of the Supreme Court's decision to annul your first severance order. And I announced this then to follow a certain amount of criticism that had been addressed to me by the Supreme Court on the way your chamber proceeded, and because we consider in our team, the Cusampan defense, that there is a bit of harm resulting from the criticism expressed by the Supreme Court, and that the main harm there consists in the difficulty of knowing when Cusampan will be actually tried on the basis of the totality of the closing order. I must say that during the proceedings in February, but also in the decision of the Supreme Court, there was, in my opinion, confusion, as I said, an amalgamation. I said it, I don't know if I was understood. Confusion between the situation of Yengsari, the situation of Mr. Nunchia in terms of his health condition and the consequences that this could have on the rest of the trial, and Cusampan's situation. As you know, Mr. Cusampan takes pride in attending all of the hearings in the morning, in the afternoon, without trying to argue or without trying to take advantage of eventual problems that he may have to not come. And you also know that he has no specific health issues that prevent him or that may lead to a pessimistic vision on his on near future. And however, he is detained still. It's been 5 years and 4 months already. And such a duration is cannot be ignored. It's 5 years is a very long time. 5 years for a man who is who was close to 80 when he was detained, and who today is 82 years old, in cells that you might have seen only a few square meters, very close to this court. That is something that is not insignificant. And I feel like saying that in most cases, the reasons delaying the proceedings here, whether it be problems of finance or whether it be procedural problems that were sanctioned in a certain way by the Supreme Court, have not been caused by Mr. Cusampan. And as of today, we have no visibility on when Cusampan will be tried on the basis of the closing order in its totality. I know that in its decision, the Supreme Court stated, and that's where I believe there was confusion, that your first severance decision in September 2011 was the same as burying, and that was the word that was used, as burying the continuation of the trial. So such reasoning is maybe appropriate to Yang Sari, but I don't see on what the Supreme Court is basing itself to argue the same for Mr. Kyosompon. But your chamber does not have the power to cancel parts of what it's been seized for. You are seized by the closing order in its totality. You have decided to adjudicate a first part of it, and this was confirmed recently, but you don't have the power to cancel all charges, which means that the difficulties that were described by the Supreme Court remain the same, and explain that the forcibility of a final judgment for Kyosompon is very, 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 very removed. And this is what I am here today asking you to notice. I'm not asking you to come up with a prejudgment. I'm not asking you to say that there's not enough evidence against Kyosompon. I'm simply asking you to say that the difficulties that you're encountering today and that we are encountering are such that it is not unfair, or even it is fair, to consider that provisional detention is no longer valid, and that the guarantees of justice that present to you, Kyosompon, allow you to understand that today, 5 years and 4 months after he was placed in detention, to consider that, yes, indeed, you can release him under bail, with the guarantee that this will not cause any problems to public order in Cambodia, and I'll get back to this, with the guarantee that Monsieur Kyosompon will present himself, as he has always done, to this chamber. He promised to do so in writing, and he will continue doing so. He will be before you during the hearings. But given his age, of course, and given the life expectancy in Cambodia, it is normal, given the lack of visibility on the date when the definite judgment will be said, that the continuation of this trial might happen for Kyosompon as he's released under bail. That is the basic thrust of our request today. And the analysis that we are conducting of the difficulties of this trial goes way back to before you were seized, in fact. And it consists in saying that, and this is public information, so that the history here of the ECCC is rather special, as you all know, and we all know that at the start, Mr. Duc had already been detained, and his case, as well as the case for the 4 other accused persons, was common at the start. And then there was this severance decided by the co-investigating judges, but we know that it was necessary for the co-investigating judges then to give priority to one case, and that was the Duc case. And then, as Khieu Samphan had been detained since November 2007, the co-investigating judges focused essentially on the Duc case in order for this case to be adjudicated. And we know that the decision to postpone the case for the 4 other accused persons was issued a few days before the legal detention order expired. I'm saying this because to underline the fact that in the history of this trial, as you can see, we're not trying to challenge your chamber. That might be a bit too simple-minded. There is just a history, a complex history with different priorities, and this is also important to remind because for months and months the co-investigating judges worked on the Duc case and not on the case that we are involved in right now. This should be taken into account because the jurisprudence that you base yourself or that you based yourselves on in your prior decisions, such as in the case of Yang Tirit, that is to say the jurisprudence of the European Court of Human Rights, clearly states that in terms of estimates for a reasonable time span for a trial, it is necessary to take into account not only provisional detention during the period of the investigation, but also as of the day when the people are presented before the chamber. 5 years and 4 months that Khieu Samphan has been detained, whereas Khieu Samphan has never attempted to go underground, even when the statutes of your court were being discussed. He was living in Phnom Penh. And it happens to be that he was one of the candidates to be prosecuted. He did not leave. He did not move. He answered the media when questioned. He remained in Phnom Penh and he confronted the prosecution. And finally, and this is an argument that may be used, even if today I don't really see the cause for this, but this is the argument of age, and which seems there is, of course, the issue of Mr. Khieu Samphan's health. But please explain to me why the health issues that he may encounter would be more serious or more difficult to treat, since he would be with his family in Phnom Penh under bail, rather than if he was detained in the detention cell right next to this court, knowing that any person acting in criminal justice is aware of the consequences of prolonged incarceration on human beings, whether physically or psychologically. I know that the prosecution is also going to raise the point of troubling public order. This was the case previously during the requests for release that were already pleaded before you, and they're going to say that Mr. Khieu Samphan, that if he's released under bail, and we're not saying that he is innocent, we're just saying that he should be released under bail with very strict conditions, well, that this would have an influence on Cambodian public order. And I would like to look at the arguments quickly here that were presented, that were already raised in the past by the prosecution. And they said to us, they used a few reactions of victims, or they based themselves on polls, and they also based themselves on the estimates, on the belief that part of the Cambodian population is suffering from post-traumatic stress. And you also underscored the fragile context of Cambodian society and the immense attention that this court is receiving from the public. And now, regarding the troubling of public order, I think we can base ourselves on a rather clear illustration, is the release of Miss Yang Terit. Miss Yang Terit, as far as I know, has not been the object of violence or any attempts of violence on the part of whoever since she has been released. It's not, I'm not challenging your court by noticing, and I had to notice that this case does not necessarily interest a great majority of the Cambodian people. Of course, people might have a good opinion of this court or poor opinion of the court, but the studies that I quote, you see that in 2008, only 3% of Cambodians were able to name the accused persons. And in 2010, after a whole campaign of sensitization, only 11% were able to do so. So that's very little. And in the documents that the prosecutor wanted to use, and we'll speak about this more in detail later, but there were documents tending to prove that these figures were even higher. So I believe it's interesting, and we'll speak about this again, but I think we should look at who is being questioned to end up with the figures used by the prosecution. And who are being questioned? Civil parties and civil party representatives. And what's absolutely flabbergasting is that among the figures that were given to us, we could see that among the civil parties, only 60% of them were able to name the accused. And even among the representatives of the civil parties, only 90% were able to name the accused. This shows that even if we play around with the numbers, even if we play around with the statistics for reasons that might be cultural or for reasons that might be economic or for various reasons, the Cambodian population does not seem to be interested in an aggressive way, I should say, or in a general way in this trial. It does not seem to be a priority. So,
également,
reasons of security were also raised. I personally find this a bit exaggerated. The prosecution, on the one hand, claims that this accused must be accused and therefore kept in detention. And then they turn around what could justify such a concern on the part of the prosecution? An assault on Mr. Khieu Samphan that dates back to 1991. We all agree and we all know that many historians, commentators, observers, journalists, politicians who were quite focused on that assault and that it had occurred in a very particular context and that the majority concluded that it was political manipulation carried out in 1991 in order to cast the impression that Mr. Khieu Samphan was a persona non grata in Phnom Penh, and that unless he was kept under complete surveillance, he should leave. Not only is this theory quite old, all evidence points to the fact that this is pure political maneuvering and manipulation, and for those reasons you cannot take that into consideration. In the past, during previous requests for release on bail, there was reference to threats to former Khmer Rouge, particularly against Duke. And I believe that since he has been tried and judged definitively, we can discard those arguments. And there was an even aggressive discussion that may have been held between Mr. Kyo Sampon's lawyer and a civil party when there seemed to be an altercation between the two before the cameras. And not only has Mr. Kyo Sampon changed lawyers since then, but I also believe that the dispute that was concerning the lawyer and the civil party didn't entail any significant consequences. In fact, to the extent that one could justify that Mr. Kyo Sampon's security would be threatened if he were to be released on bail. Today, and this brings me to the conclusion of my pleading, since you have only accorded me 30 minutes. Today, Your Honors have the possibility to prevent all risks if you believe such risks to be real. We, the defense for Mr. Kyo Sampon, propose that Mr. Kyo Sampon released to a known residence and that it not be changed without the authorization of this court. We have also conveyed all information regarding the residence where Mr. Kyo Sampon could settle, where it is situated, and we have also communicated to you his personal commitment to abide by the Chamber's orders, his undertaking to hand over his passport and any identification papers. And as you will recall, Mr. Kyo Sampon has never sought to abscond or flee justice. And contrary to what the prosecution says, he has never tried to draw a financial benefit in talking about his role during democratic Kampuchea. He's never sought to amass wealth or riches based on that. This is an individual who has always carried out a rather simple and humble life up until the day that he was arrested. He simply has no means to leave or flee. Given his age, he technically and financially simply does not have the means. Lastly, Mr. Kyo Sampon has also taken the undertaking, if you do decide to ultimately place him under bail, to not contact the media, to not be in communication with journalists, and to not be in communication with anyone other than his lawyers. Nor will he be drafting any articles or writing any books. He will be focused entirely on this trial. Quite obviously, there will be absolutely no contact with the civil parties. He has been in contact during this trial and on previous occasions. And obviously, he will obey all of the strict conditions that your chamber would impose with respect to his residence. At his age, Mr. Kyo Sampon has absolutely no intention of leaving his home to live the life of a young man. He is an 82-year-old man. He will stay at home, and he will be cared for by his relatives and his family. And that is all he asks for. He will abide with assistance, if the chamber so decides, to do his utmost and participate in his defense before this trial and before this chamber. I believe our application is rather clear and straightforward. You yourself, Mr. President, have on many an occasion indicated, including as early as this week, the financial difficulties that this tribunal faces, as well as some of the procedural difficulties we are mired in. All I ask is that you take into consideration that Mr. Kyu Sompong has absolutely no foreseeability as to whether or not this trial, this ongoing trial that concerns him, and I believe that it was during the Duke trial that Judge Cartwright may have said that it would take approximately 8 months to come to a definitive judgment. I don't recall the exact time frames, but for such a trial it could take double the amount of time. And as I have recalled, there may still be subsequent trials following this one. Therefore, a definitive judgment is still very remote, at least on the first segment of this trial, much less the totality of this case. And that is what I wish to impress upon you today, that is to release Mr. Kyu Sompong under immediate release on bail on the strictest conditions. Thank you.
The President, Counsel for Mr. Kyu Sompong, please rise. I have a question. Your request is for Mr. Kyu Sompong to be released on bail, and you already expressed the measures you would like to be imposed on Mr. Kyu Sompong. However, the Chamber has not yet heard if he were to be released, how would he come to the Chamber? I mean, how would he appear before the Chamber?
Deux possibilités.
I believe that there are two options. The first would be to allow him to come on his own means and arrive by taxi, as many of us do, during the morning and the evening. And the second option, as outlined in the application before you, would be, if the finances of this tribunal permit, and if there's a car available, if you, Your Honors, decide that this would only reinforce some of the restrictions you place eventually, it would be to provide a car and have him transported. Then I think those are the only two options before us. Mr. Kyu Sompong and his relatives propose to assume the full cost of transportation if the court is unable to ensure that. There is absolutely no issue on that front. But if you consider that providing court transportation is a reinforced measure, then that is also an option.
The President, the judges of the bench wish to put any questions to counsel on this before we can finally rule upon the application. Judge Sylvia Cartwright, you may now proceed.
Yes, Maitre Verken, I certainly do not question the truthfulness of the offers you make in your application for release of Mr. Kyo Sampan, going to conditions that the court might impose. But it is usual, I would have thought, to have something more than just various offers of possible conditions which seem to reflect very closely those that were put forward in relation to Ying Tirit. So I would like to ask you just a couple of specific questions, please. First, we have absolutely no indication, so far as I am aware, of where Mr. Kyo Sampan would reside should the Chamber be prepared to release him on bail. Secondly, you say he's indigent. Do I have any material before me to support that contention? It may well be correct because he has been assigned counsel, but simply to accept it from the bar is a little unusual for me, and so I'd like just a little bit more information, please, before being able to consider seriously such a serious request. So perhaps you could expand. Thank you.
Alors, sur les
Your Honor, these documents are annexed to the application for Mr. Kyo Sampan's immediate release on bail. All of the relevant documents have been attached. There is a land title, there are written undertakings, there is the identification of those who would surround Mr. Kyo Sampan, as well as the address. All of these pieces can be found in the annex of our application E275.
You may well be right about that, Maitre Verken. I do now recall that when I looked at this application, I couldn't find the annexes, hence my questions now. But could you just reassure me, please, that we have full information, including whether he has a current passport or not?
Alors oui.
He does not have a passport. Mr. Kyo Sampan, do you have a passport? But I'm sure your honors may ask the Cambodian authorities. Can you not hear me? He does not have a passport, Your Honor. I believe that all of the documents have been conveyed. They were notified at the same time as the application. There's information on his address, the type of property, as well as the names and identification of all those who would be residing with him. They are on the case file, and as far as the matter of indigence is concerned, perhaps there was a misunderstanding in the translation, but I never uttered that. I never talked about his status as an indigent person. Mr. Kyo Sampan has a family. And if your chamber does not seek to ensure his transportation to the tribunal from his residence, or if you do not intend to ask the Cambodian authorities to undertake that duty, perhaps the Cambodian police could fulfill that duty, well then, the family of Mr. Kyo Sampan would assume the costs of taxi transportation. But there was never an issue of indigence.
Well, the translation I received was, he has no means with the appropriate gestures, so I took that as indigent. Is that a different meaning?
Je ne sais pas, en fait.
I'm not entirely sure. I'm not entirely sure, but based on Judge Laverne's reaction, I don't believe that it was ever brought up. Perhaps it was just a misunderstanding caused by the lag in interpretation.
The President, Judge Lavigne, you may now proceed.
For the sake of clarity, are we to understand that Mr. Kyo Sompon does have sufficient means to live with his family? Counsel Verken, absolutely. And that's exactly the substance and meaning of some of his undertakings and written statements. I didn't want to enter into detail during these proceedings, but that is exactly the case. His family has decided to undertake all of the costs involved in his living if he were to be released on bail.
The President, since it is now appropriate moment for the adjournment, the Chamber will adjourn until 3 o'clock.
Som Prok Cho.